Some of you that attended our webinars earlier probably know that we talked a bit about the right to education and discipline in education and special needs students. And this time I wanted to talk about something that's quite topical and quite sort of a big issue nowadays, and that's sort of cyberbullying and social media. So it's really kind of a new developing area. A lot of what we're going to talk about today is a bit about the law and just some of the new laws that have come into effect to help protect young people and how that would relate to the school environment. Yeah, and just Velda's just reminded, if you're able to, just star one, just that stops any feedback on the webinar as well. To mute the phone. Great, so let's get started. So social media, everyone knows, and it's become pretty apparent that young people are growing up more and more with technology and using social media to become more and more connected to their friends. Almost every young person I know has a smartphone, has access to the internet, has a Facebook account, a Twitter account, Instagram, and you know, it's really becoming a really commonplace for most young people. They're probably a lot more internet savvy than people that are older than them, so it is going to be an issue if there are things like cyberbullying going on or personal details and information are being shared online. So we're hearing more and more, and definitely on YouthLaw's advice line, we're hearing a lot more and more about things like cyberbullying. So what does cyberbullying look like? It's pretty wide. It can involve things like sending anonymous text messages or picture messages to someone's device, posting threatening or nasty comments on someone's social networking profile like Facebook. People are even hacking accounts or creating fake profiles and things like that, or even catfishing and using someone else's profile to present themselves as that person. Circulating photos or videos that are either real or altered, which can be pretty damaging, and also spreading rumours about people on sites. So one really common query that YouthLaw gets on the advice line is about a site called ANZASW. I'm not sure if you would have heard of it, but if you are supporting a young person, there's potential you might hear about this at some stage, which is a site which enables anonymous postings about particular people, and it can be incredibly upsetting for a young person to read all these things posted about them, which can be quite nasty on the site. It is a problem. It's an ever-increasing problem, so I'm definitely noticing a trend in terms of the queries that are being received, an ever-increasing problem for young people because they are exposed to so much social media, so many smart devices. And yes, schools also really have a legitimate concern in this because they are required to provide a safe physical and emotional environment under the Education Act and Ministry of Education policy for students. And the National Administration Guidelines set out in detail for schools the obligation to make sure that students are kept healthy and safe at school and not exposed to unreasonable risk or harm. And there's a good argument to say that if they're being cyberbullied and they're feeling suicidal or acting out violently because of that, then the school's going to have a legitimate interest in trying to prevent that and making sure that students are safe and healthy at school. Is it a big deal? Some of the research is pretty scary. For instance, 1 in 5 high school students actually report being bullied. I think this is in the Youth 2000 survey. So it's a pretty high percentage. At least 1 in 5 will have experienced some sort of harassment or abusive behaviour. And research in the UK has shown that cyberbullying, because it continues away from the school grounds, and at any time of the day or night, it can actually have more of an impact than being physically bullied because the mental strain is continuing to affect the student beyond the ordinary school day. So yeah, the impact of the new technology is quite big, and I guess schools are still trying to learn how to deal with some of the jurisdiction or protection issues that come out of it. because social media is so wide, essentially once something is posted online, it's available instantly and in numerous countries, and there's a paper trail, essentially, an electronic paper trail that you can always then Google about this person. Traditionally, school jurisdiction was a little bit more limited, and it was understood that when schools were making rules and things like that, that their jurisdiction historically extended to when students were at school, in school uniform, within school time, on school premises. And then after that, it was up to the parents or caregivers to take over jurisdiction of the student. So one of the really sort of old rules of thumb was that if a student was within a 500-metre line of sight from the school might still have a legitimate interest in what the student's doing, or if they're out on a school trip in school uniform, the school would have a legitimate interest in what they're doing. I guess the impact of technology has sort of changed that quite a bit, because the reach of smart devices and internet is much wider. So a student could be bullying another student, and it could be happening at night when they're both at home, both not at school, both not even in school uniform, but it could actually spill over into a fight at school, so the school probably has a legitimate interest in it. Wider issues sort of arise around this as well. So, for instance, students that are using school computers to cyberbully, it's school property, so the school probably has a legitimate interest in controlling what type of content students use the computers for. And I'll talk about this a lot more in one of our later webinars, but it really has a big impact on the traditional search and seizure powers of schools, and how they can search and seize things that students might have in their possession that might be harmful. So students may have a smart device in which they've been using to bully another student, and there's a question around schools' jurisdiction and powers to retain those devices. And, like some of the more controversial topics that we sort of get asked about is things like whether a teacher can force a student to reveal a cyberbully post, or a really explicit post about another teacher at the school, which the school would have a legitimate interest in if it's affecting staff relations or student relations. I will talk a lot more about that in more detail in one of our webinars that's coming up, just dealing specifically with search and seizure in schools. So won't go into too much detail in this particular webinar, but it's something that I'll talk a lot more about in like specific rules that a school might be able to apply, and how the law applies when you're dealing with search and seizure of electronic devices. So I think there's been a real recognition that it's a real issue. I think Justice Minister Judith Collins had spoken at length about this a number of times, and noted that it's a real dangerous area that our young people are being exposed to, because it's very easy to provide personal information online. It's very easy for there to be immediate posting to a wide audience. And very often, if a young person is on a smart device, their parent doesn't necessarily know exactly what's going on at 100% of the time on the smart device, who the young person is talking to, or if they're being cyberbullied. So a new law was introduced, obviously, because a lot of the old law under the Crimes Act or Harassment Act really wasn't fit for purpose in terms of dealing with cyberbullying, because instead of things like physical harassment where you can trespass someone from premises, or the Crimes Act, which would deal with traditional assault, physical assault of a person, the laws weren't quite fit for purpose in terms of targeting the different types of conduct which might constitute cyberbullying. So, anonymous text messages, posting or circulating a picture on private social networks of another person without their consent, not neatly covered by existing laws like the Crimes Act. So there was the introduction of a new law to sort of try and give the police the power to charge people with offences if they were doing such things, particularly where they couldn't get it to fit within any other legislation. So the piece of law that was introduced was the Harmful Digital Communications Act. Section 3 of the Act sets out the purpose of the Act, so it says it's intended to deter, prevent and mitigate harm caused to individuals by digital communications. and it also is intended to provide victims of harmful digital communications with a quick and efficient means of redress. So, I mean, historically, when police may have investigated a crime and it may have gone through the process of being charged and going through the court process, there could be a significant delay between the time the charges were laid and the time that the matter was actually heard in court. And part of the aim of this legislation was to try and provide a quicker means of redress, particularly when you think about the fact that if something's happening online, it's happening instantaneously, and the damage can be very quick and very fast. So quick and effective fast response is probably preferable rather than a number of months, 6 to 9 months down the line. So Section 6 sort of has the key principles. So if you're ever supporting a young person and you're just sort of needing to know what sort of things are not appropriate in terms of online communication covered by the law, these sort of principles set out what the protections are meant to be under the law, essentially, and sort of guide how you interpret whether or not offence has been created and the evidence that supports that. So Principle 1 is that a digital communication should not disclose sensitive facts about an individual. Principle 2, a digital communication should not be threatening, intimidating or menacing. Principle 3, a digital communication should not be grossly offensive. Principle 4, a digital communication should not be indecent or obscene. Principle 5, a digital communication should not be used to harass an individual. Principle 6, a digital communication should not make any false allegation. Principle 7, a digital communication should not contain matter that is published in breach of confidence. So I guess one of those things that sort of we hear a lot about on our advice line is, for instance, young people who've shared quite private photographs with each other, shared in confidence, and then suddenly when the relationship has ended, that picture's been published to all of that person's friends on Facebook or something like that, social media. That would probably be something that you could say sits squarely within Principle 7. Would it be a breach of that, that confidence? Principle 8, a digital communication should not incite or encourage anyone to send a message to an individual for the purpose of causing harm to an individual. So some examples that I can sort of think of, and if you're supporting young people, you might come across these as well, is, we sometimes get calls from young people where other people at school have been sending them messages on social media saying you should kill yourself, or, you're ugly, or something like that. And that would, sit squarely within Principle 8, telling them to cause harm to themselves and intended to prevent sort of many of the harmful effects such as suicidal tendencies if a person is being cyberbullied. Principle 9, a digital communication should not incite or encourage an individual to commit suicide. So again, just taking it a step further. Principle 10, a digital communication should not denigrate an individual by reason of his or her colour, race, ethnic or national origins, gender, sexual orientation or disability. So not only, you'll remember I talked a little bit about this when I talked about the special needs of students in our special needs webinar, but you've also got the protection under the principles of this particular Act, as well as additional protections under the Human Rights Act and Bill of Rights Act for any discriminatory treatment of another individual. I guess this is aimed at preventing private individuals from denigrating people by virtue of grounds of discrimination, whereas the Bill of Rights and the Human Rights Act was aimed at regulating, for instance, public service education. So how is an offence defined? Because obviously there's all these principles, so how do the police interpret this legislation to sort of say, well, in this case, someone's breached the law? So the offence is defined as causing harm by posting a digital communication. So posting would be, say, for instance, putting something on Facebook, sending something to Twitter or Instagram or something like that. Section 10 sets out who can bring proceedings, so who can actually enforce when a crime has happened. So an application could be made to the district court by an individual, their parent or guardian if they're underage, or the police if they consider there's been a threat. So some of the time it might just be easier if you're supporting a young person to support them in going to the police and reporting this offence, and the police can actually make an application to the district court to enforce the law as well. I think quite recently, and you may be able to find it after the webinar by doing a search in the New Zealand Herald website, there's quite an interesting breakdown on the New Zealand Herald website quite recently of the types of cases that were being heard and the convictions that were being found under the new sections. So a lot of them have had to do with sort of harassing texts or offensive posts. So yeah, quite an interesting article if you get the chance to pop on the New Zealand Herald website. It kind of talks about the types of cases that have been taken by the police, primarily by the police actually. I don't think there were any listed taken by individual people. So it sort of shows, you know, how the police interpret and apply the law and take these charges forward. And it can provide a really good support for young people, obviously, because then they can seek to have the cyberbullying stopped. And then, as I'll talk about a little bit later in the webinar, there are other remedies available other than just stopping the cyberbullying. So, for instance, if something's been published, there are powers in terms of getting that removed as well, which I'll go into more detail about. So under Section 12, it sets out the threshold that you actually have to meet before you can take proceedings, and the district court will actually say, yes, there's been a breach of this particular act and we're going to enforce it. So a district court cannot grant an application unless it's satisfied that A, there has been a threatened serious breach or repeated breach of one or more of the communication principles. So, I mean, serious breach obviously would say, you know, not something trivial. It has to really meet the threshold. And B, the breach has caused or is likely to harm the individual. Now, that's a little wider because you don't actually need to show that harm has been caused. It's just necessary to show that it's likely that this person is going to be harmed, which is a bit of a lower threshold, which is quite good because if you were only going to wait for people being shown that they'd been harmed, you would really be not protecting a large, substantial portion of, say, vulnerable young people who haven't necessarily suffered harm yet. And under Section 18, it sets out the interim orders that are available to the court where needed. So if the court thinks it's appropriate, they can issue some interim orders upon hearing the case. And Section 19 sets out orders that can be made by the court. So, for instance, the court can order that the particular person take down or disable the material. So, a person might be told to remove a Facebook post, for instance. The court can also mandate an order that the defendant cease or refrain from the conduct of which has been complained. So, stop doing that. Stop sending those harassing text messages. Stop sending those nasty messages through Facebook. The court can also order that the defendant not encourage any other persons to engage in similar communications. So, you know, it is quite common, for instance, say if a young person is broken up with their significant other, that their friends might start then messaging nasty messages. So the law is intended to be wide enough to ensure that people that are associated can also be stopped from doing that as well. So it's not just passing on the ability to do that to someone else. Further orders include things like requiring a correction be published. So if someone's blatantly posted something really false about someone, it could order that that correction be published. Oh, and David, I see your question there about the New Zealand Herald reference. Yes, I'll definitely have a quick Google at the end of the webinar and try and post the link in the chat box. I think just doing a search for cyberbullying in the search function of the New Zealand Herald should bring it up, but I'll do my best to look for that after the webinar as well. Yeah, and so other things that can be ordered under Section 19, that a right of reply be given to the affected individual. So if someone's posted something really inflammatory and I really wanted to have a reply to that, like to sort of have my say and put my perspective, the court might order that if they thought it was appropriate. The court can even order that an apology be published. So, you know, quite wide-ranging powers, and I guess intended to cover lots of different situations because sometimes it may be appropriate that an apology be published rather than a correction. The District Court can also, on application, make these following orders against an online content host. So we're talking about two different possible offenders under the legislation. Just winding it back, when I was talking before, I was talking about individuals. So when an individual's posted something, or they're doing something, or harassing someone, the court can order that they stop that or take down their material or cease doing what they're doing. Where you've got an online content host, so for instance, Orcon or Telecom is hosting content for someone, the court may also, if they think it's appropriate on application, order that this online content host take down or disable public access to some material. Also may order that the identity of the author be released, which is quite powerful because then you would know who had created that offensive material. The District Court can also order that the online content host, so remember not the person, but actually the person that's hosting this person's material, so Telecom, Orcon, Vodafone, whoever it is, that a correction be published, and may even order that the online content host has to give that person a right of reply or publish an apology. So it does also impose powers on the court to regulate online content hosts as well. Under Section 21, it deals with what happens when people don't comply with what the court orders. So under Section 21, there's an offence of non-compliance, and people are liable on conviction to A, in the case of a person, so we're talking about natural people or individuals, imprisonment for a term not exceeding 6 months or a fine not exceeding $5,000. And as I said, David, I'll find that New Zealand Herald reference, but in that article it also describes the type of orders that were made and the types of fines that were given in that article, so it could be an interesting read. And B, in the case of a company, so i.e. not a natural person but a company or a legal entity, a fine not exceeding $20,000. So quite a bit higher. I guess the idea being that companies probably shoulder, a sort of higher level of culpability or responsibility in terms of making sure that they're not putting up offensive material or things like that. Section 24 sets out the process for obtaining protection against liability for specific content. So no civil or criminal proceedings can be brought against an online content host in respect of hosting specific content complained where the host has followed the process for notifying the author in Section 24 and requiring action. So obviously if Telecom or Vodafone is hosting some online content for a person and they become aware that there is objectionable material in there, and they contact the author and follow the process saying, look, you need to do something about this, you need to take it down, or whatever. If they've done all that they can do and they've followed processes, then they can't be brought to task over that. So I guess the thing is, even though the court has quite wide powers to go after online content hosts, if they do everything they can and follow the process, then it's unlikely that charges would follow against them, possibly against the individual. So the Act has also amended quite a few other bits of law. So you'll remember I talked a little bit before in the webinar about the fact that the Crimes Act, the Harassment Act, Trespass Act, all those sorts of things were all sort of bits and bobs of different bits of law, but they didn't really help cover the unique situation and different situations that could arise in online or cyberbullying. So, under the Crimes Act, there was Section 179, aiding and abetting suicide. The definition was sort of a bit of an older definition that didn't cover all the possibilities around what might happen in a cyberbullying context or a social media context. So it's just now been updated to ensure that it does. The same with the Harassment Act. So under the Harassment Act, the older version of the Harassment Act had things, like physical harassment or postal harassment or things like that. And the Act has now been widened to ensure that the definition of harassment and conditions of restraining order covers things like electronic media and social media and, cyber-type bullying. In particular, you'll see there I've cited Section 3, Sub 4. It notes that a continuing act includes where offensive material is placed in electronic media. So that's really nice and broad and would cover situations where you're dealing with social media or the impact of cyberbullying, which might not have been covered under the old definition. And like I said, and I talked about it before, the fact that there are still protections against discrimination, obviously, under the Human Rights Act and the Bill of Rights Act and things like that. But the Human Rights Act has now been amended to reflect that, and it has sections relating to racial disharmony and sexual harassment through electronic communications, which wasn't necessarily covered within the old definition before. So it has resulted in changes across the board, but also it's quite a new piece of law, so we're still waiting to see how it plays out. You might have heard recently there's an announcement that NetSafe has secured the contract for services to provide the function of investigating the complaints. So it'll be very interesting to see how that all kind of pans out in the future. But at the moment, it's still quite a new law, which was why this article in the New Zealand Herald was quite nice. It talked about the fact that a lot of the cases are still new and they're still feeling their way around the law. So you've only got sort of a small handful of cases to look at the type of orders that are given and the type of cases that are coming before the courts. So I just wanted to talk a little bit more about just prevention, because I guess usually when a child is in a situation where they're being cyberbullied, it may have been going on for some time, and usually the parent or guardian or support person may not have become aware of it until it's actually quite serious and the young person is quite psychologically impaired because of it. So, I mean, not only, and you'll remember I talked in the earlier slides about the National Administration Guidelines and obligations through Ministry of Education Policies and Education Act, and also international law, so refer back to our webinar of right to education. But schools are required and obliged to have policies in place to protect against social media abuse and how it is to be dealt with. I'll talk a little bit more about this when I talk in the search and seizure webinar, but obviously schools need to provide rules to protect students, but obviously that has to be tempered against the student's right to privacy and right to freedom of speech under the Bill of Rights Act. So obviously forcing a student to reveal a Facebook password, there's some issues around that, and I'll talk a lot more about it in the search and seizure webinar, but school rules should be able to address the situation but not impinge on other rights such as the Bill of Rights Act rights. Outside of the school's own policy and their own internal mechanisms for dealing with it, so for instance they may have a disciplinary policy which relates to defining serious cyberbullying and action to be taken when cyberbullying is found out. Outside of the school's own policy, social media sites also have their own terms and conditions which set out appropriate conduct and appropriate means of communicating on that forum. So there are times, and we often do receive calls on our advice line about this, it might be worth contacting Facebook to say, look, this post is really objectionable, it's something that you should remove, and sometimes they will do that. So Facebook's Code of Conduct protects users from sexual content as well as offensive acts. So it would be a matter of getting in contact with the Facebook administration office and letting them know this post is offensive or these messages are offensive and I'd like them to be removed. So these are sort of the top take-home tips. It's really just a really broad overview of the law because it's such a new case of law that we don't really have a lot of cases to refer you to. It's just still developing and we're still learning at this stage, but I will get that New Zealand Herald article link to send into the chat box. I think it's a step forward in the sense that young people are much better protected under this legislation than they were previously because police weren't given the power to possibly investigate and lay charges in other situations where there was cyberbullying or abuse on social media. That's the sort of take-home tip for today. If you want some more information, obviously there's lots more on our website. Occasionally we do put some stuff on Facebook about it, and we do sort of cartoons and infographics setting out basic information and rights. If anything occurs to you after the webinar that you sort of need to ask about and just want to ask, feel free to flick us an email or submit a query on our website. A lot of the information that I've talked about is also available in a smartphone app. So YouthLaw now has a smartphone app which is free to download on the Google Play Store or the iTunes Apple Store. For those that join the webinar a little bit later, can I just also reiterate that if there's a number of you that have signed into one computer, I'd greatly appreciate if everyone could type their names into the chat box, just so we can keep a record of the number of people attending. And those that have sat through the webinar, would greatly appreciate if you could just take a few minutes to do our SurveyMonkey survey. It just lets us know whether you find the webinars useful, what you think would be useful in the future, and how we can improve them. And it's also required for our reporting purposes on the types of webinars that we're delivering. And I can see your question, Wendy. We'll definitely have this in PowerPoint up on our website after the webinar. And hopefully, depending on workload of our fantastic tech, Velda will be putting together a video with this audio on YouTube, which can be accessed at any time as well if anyone wants to re-watch it. So hopefully that's helpful for you too. I'm going to do my best to try and find out that New Zealand Herald link whilst I've still got the chat box open with everyone. But feel free to ask any questions that you do have through the chat box, and I'll just answer them as they come along. And yes, thank you very much for tuning to the webinar, and apologies for getting started today.